Hi, I'm Anisha, your AI study partner with License to Learn. Before we get started, I want to thank our sponsor, License Closet, for supporting this video. License to Close offers an affordable way to hang your real estate license for just $149.99 per year with no MLS required. This is a great option for agents who want to stay active, keep learning, and build at their own pace. You'll find the link below. This video is for educational purposes only. Florida real estate laws, rules, and procedures can change, so always verify current requirements through official Florida sources before relying on this information. This content is Florida specific and is a study guide, not a substitute for completing a state-approved course. Now let's get into today's lesson. Today's Unit 11 mission, real estate contracts, the paperwork that turns "we're thinking about it" into "we're locked in." Think of a contract like a seatbelt for a deal. It doesn't make the car go, but it keeps everyone from flying through the windshield when things get bumpy. On the Florida Sales Associate exam, contracts show up everywhere, listing agreements, purchase contracts, options, required disclosures, and what happens when someone breaks the deal. Plain English definition. A contract is a legally enforceable agreement between two or more competent parties. Rapid exam drill. Answer out loud. What are the essentials of a valid contract? Answer. Capacity, competent parties. Offer and acceptance, meeting of the minds. Lawful object and consideration. Let's break down those essentials like a recipe. 1. Capacity, competent parties. Competent means legally able to contract. If someone lacks capacity, the contract may be void or voidable. Rapid exam drill, void versus voidable. What's the difference? Answer. Void never had legal effect. Voidable, never valid, unless the protected party chooses to cancel. 2. Meeting of the minds. That's real agreement on the same deal terms at the same time. No, I thought you meant energy. 3. Lawful object. If the purpose is illegal, the contract is void. 4. Consideration. That's the give and get. Money, a promise, something of value. Quick exam trap. Does consideration have to be equal? Answer, no. It must be legal and real, but not necessarily equal. Keep these labels straight. Valid, now enforceable. Unenforceable, now bars, looks like a contract, but the law won't enforce it, often because a required form rule isn't met. Now the exam loves offer and acceptance because that's where deals fall apart. Offerer, the person making the offer. Offeree, the person receiving the offer. An offer must be clear and definite. Price, property, parties, and key terms. Rapid exam drill. What is a counteroffer? Answer. A rejection of the original offer and a brand new offer with changed terms. That means this is a trap. If the seller changes one line and sends it back, the buyer's original offer is dead. The seller is now the offerer. How offers terminate? Common exam list. Rejection by the offeree. Counteroffer, revocation by the offerer before acceptance is communicated, lapse of time, expiration, death or incapacity of a party, destruction of the property, illegality, rapid exam drill. When is an offer accepted for exam purposes? Answer, when acceptance is communicated in the manner required by the offer, not just "I signed it and kept it in my drawer." Next, contract types, the name that contract style questions. Bilateral contract, promise for a promise. Most purchase contracts are bilateral. Unilateral contract, promise for an act. The classic example is an option contract structure. Seller promises to hold. Buyer performs by paying option consideration. Express contract, stated in words, written or spoken. Implied contract, created by actions, behavior. Executory versus executed. Executory, not fully performed yet. Executed, so fully performed. Formal versus informal. Formal is created in a special way, like under seal in old school concepts. Informal is the normal everyday contract. Rapid exam drill. Parole contract means what? Answer, oral, not written. Now, Florida style reality. Real estate is where writing matters. The Statute of Frauds requires certain contracts, like contracts for sale of land and leases longer than 1 year, to be in writing and signed to be enforceable. Statute of Frauds versus Statute of Limitations. Do not mix these up. Statute of Frauds must be in writing to be enforceable. For real estate, this often means the contract for sale of real property must be written and signed. Statute of Limitations, how long you have to sue. In Florida, actions on a written contract generally have a longer limit than actions on an oral contract. Rapid exam drill. If a contract is enforceable but time runs out to sue, what is that called? Answer, it becomes time barred by the statute of limitations, practically unenforceable in court. Breach and remedies. Rescission, undo the contract, put parties back. Damages, money to compensate. Liquidated damages, a pre agreed amount, often tied to deposit language. Specific performance, court orders the party to perform. Common real estate remedy because land is unique. Rapid exam drill. Why is specific performance common in real estate? Answer, because real property is considered unique. Money alone may not make the buyer whole. Now, contracts that matter most to real estate licensees. Listing agreements and sales contracts. Listing agreement, that's just employment agreement between the owner, principal, and the broker. Sales contract, that's just agreement between buyer and seller. Florida exam favorite, types of listings. 1. Open listing. The owner can list with multiple brokers. Commission goes to the procuring cause. 2. Exclusive agency listing. One broker is authorized, but the owner can sell without paying a commission. 3. Exclusive right of sale listing. One broker is paid no matter who finds the buyer, as long as it sells during the listing term. 4. Net listing. The owner keeps a set net amount. Broker keeps the rest. Legal conceptually, but high risk and often discouraged because it can create a conflict of interest. Rapid exam drill. Which listing gives the broker the strongest commission protection? Answer, exclusive right of sale listing, required writing point for listings in Florida. If a broker uses a written listing agreement, Florida law requires a definite expiration date, and a copy of the signed listing must be given to the principal. Sales contracts, what's typically inside and what the exam targets. Common items tested, closing date, time, place. Purchase price, financing terms, type, quality of title to be conveyed, type of deed, personal property included, evidence of title, prorations, signature authority, including attorney in fact under a power of attorney, key term, POP, attorney in fact, so a person authorized by a power of attorney to act for someone else. Assignment versus novation. Assignment, white, where skanks transfer. Rights, interest to another party. Original party may still be liable unless released. Novation, whites substitute a new party and release the original party. Requires consent. Rapid exam drill, assignment and novation. Which one releases the original party? Answer, novation releases the original party. Assignment typically does not. Fraud versus culpable negligence. Fraud airs intentional misrepresentation of a material fact. Culpable negligence, reckless disregard for consequences, more than a simple mistake. Disclosures. The exam expects you to recognize in or alongside a contract. Radon gas disclosure. Florida requires radon disclosure language in real estate contracts. Homeowner association disclosure. Summary. If the property is in a homeowner association, Florida law requires a specific disclosure summary to the buyer. Property tax disclosure summary. Florida requires a property tax disclosure summary in the contract package. Lead-based paint, federal. Most housing built before 1978 requires the lead-based paint disclosure process before the buyer tenant is obligated. Material defects disclosure, Florida seller disclosure rule for latent. Material defects is tied to the Florida Supreme Court case Johnson versus Davis, especially for residential. Not a material fact, Florida law. Florida law says certain stigmas like deaths or HIV/AIDS are not required disclosures unless another law requires it. Code enforcement and building code issues. Exam idea. When in doubt, disclose and don't misrepresent. Certain pending enforcement situations can trigger required notice. Rapid exam drill. If you're unsure whether something is material, what's the safest exam answer? Answer. Disclose and document. And when it gets legal, send it to an attorney. Option contracts, a top Florida exam target. An option is basically, I'll hold this offer open for you. It's usually structured as a unilateral contract. The seller promises to keep the option open and the buyer pays option consideration. Critical exam point. Without consideration, an option can be revocable because there's no give supporting the hold it open promise. Rapid exam drill. What makes an option different from a normal offer? Answer. The buyer pays consideration to keep the offer open for a stated time. Licensee role and safety line. Real estate licensees typically use attorney-prepared forms and fill in blanks for straightforward transactions. Drafting legal language or giving legal advice crosses into the unlicensed practice of law. That's when you hand it to an attorney. Fast recap. Contracts equals capacity, plus offer acceptance, plus lawful object, plus consideration. No contract types, know how offers terminate, no remedies, no listing types, no disclosure concepts, no options and consideration, no fraud versus culpable negligence. Welcome to Key Terms, where we turn real estate words into real estate understanding. Let's begin. Key term contract, meaning a legally enforceable agreement between two or more parties. Memory hook, contract, enforceable promise. Key term, capacity, competent parties, meaning legal ability to enter a contract. Wrong answer magnet, assuming adult always means competent. Competency can be affected by legal status or mental capacity. Key term, offer and acceptance, meeting of the minds, meaning both sides agree to the same terms at the same time. Memory hook, same deal, same time. Key term, lawful object, meaning the contract purpose must be legal. Key term, consideration, meaning something of value exchanged, money, promise, benefit, or detriment. Wrong answer magnet, thinking it must be equal value. It must be real and legal, not equal. Pause and answer. What are the essentials of a valid contract? Answer. Capacity, offer, and acceptance. Lawful object, and consideration. Key term, valid contract, meaning meets all essentials and is enforceable. Key term, void contract, meaning no legal effect from the start. Memory hook, void, 0. Key term, voidable contract, meaning valid unless the protected party cancels it. Memory hook, voidable, thus one side can void. Key term, unenforceable contract, meaning looks like a contract, but the law won't enforce it, often because a required legal form rule wasn't met. Key term, mutual consent, meaning both parties freely agree. No misrepresentation, fraud, duress, or undue influence. Pause and answer. Void versus voidable. What's the difference? Answer. Void never had legal effect. Voidable is valid until the protected party cancels. Key term, offerer, offeree. Meaning, offerer makes the offer. Offeree receives it. Key term, counteroffer. Meaning, rejects the original offer and creates a new offer with changed terms. Wrong answer magnet. Thinking a counteroffer keeps the original alive. It does not. Key term, revocation. Meaning, offerer withdraws the offer before acceptance is communicated. Key term, lapse of time, expiration. Meaning, offer ends when the time period passes or a reasonable time passes. Key term, termination of offer. Meaning, rejection, counteroffer, revocation, expiration, death, incapacity, destruction of property, or illegality. Pause and answer. If the seller changes one term and sends it back, what happened? Answer. That's a counteroffer. The original offer is rejected, and the seller is now the offerer. Pause and answer. When is acceptance effective for exam purposes? Answer. When acceptance is communicated as required by the offer. Key term, bilateral contract. Meaning, promise for a promise, typical purchase contract. Key term, unilateral contract. Meaning, promise for an act, often tested with options. Key term, express contract. Meaning, written or spoken words form the agreement. Key term, implied contract. Meaning, agreement formed by actions and conduct. Key term, executory contract. Meaning, not fully performed yet. Key term, executed contract. Meaning, fully performed. Key term, parole contract. Meaning, oral contract. Pause and answer. Most purchase contracts are bilateral or unilateral. Answer, bilateral. Pause and answer. Executory means what? Answer, not fully performed yet. Key term, Statute of Frauds. Meaning, certain contracts must be in writing and signed to be enforceable. On the exam, think sale of real property and leases longer than 1 year. Wrong answer magnet. Mixing this up with time limit to sue. Key term, statute of limitations. Meaning, time limit to file a lawsuit. Key term, breach of contract. Meaning, failure to perform as promised. Key term, rescission. Meaning, cancel the contract and restore parties as much as possible. Key term, damages. Meaning, money awarded to compensate for loss. Key term, liquidated damages. Meaning, pre-agreed amount if someone breaches, often tied to deposit language. Key term, specific performance. Meaning, court orders performance, common in real estate because property is unique. Pause and answer. Statute of Frauds means what? Answer. Must be in writing and signed to be enforceable for certain contracts. Pause and answer. Why is specific performance common in real estate? Answer. Because real property is considered unique. Key term, listing agreement. Meaning, employment agreement between the owner and the broker. Exam note, written listings must include a definite expiration date and the principal should receive a copy. Key term, open listing. Meaning, multiple brokers allowed, commission goes to the procuring cause. Key term, exclusive agency listing. Meaning, one broker, but owner can sell without paying commission. Key term, exclusive right of sale listing. Meaning, broker earns commission if it sells during the term, no matter who finds the buyer. Key term, option contract. Meaning, buyer pays consideration to keep an offer open for a set time. Wrong answer magnet. thinking an option is just a normal offer. The key is option consideration. Key term, attorney in fact, meaning person authorized under a power of attorney to act for someone else. Key term, assignment versus novation, meaning assignment transfers rights, interest. Original party usually still liable unless released. Novation substitutes a new party and releases the original party, requires consent. Pause and answer. Which listing gives the broker the strongest commission protection? Answer. Exclusive right of sale listing. Pause and answer. Which one releases the original party? Assignment or novation? Answer. Novation. Florida laws and rules can change. Verify the most current requirements through the Florida statutes, Florida Administrative Code, DBPR, and the Florida Real Estate Commission. Before you go, make sure you like, subscribe, and share this video with anyone who's preparing for the Florida real estate exam. If this lesson helped you, that tells me I'm doing my job. And if you're ready for more structured support, live instruction, and accountability, you're invited to join our online classes through License to Learn. You'll find the sign-up link below. Keep showing up, keep studying, and keep building the future you're working toward. I'll see you in the next lesson. Florida laws and rules can change. Verify the most current requirements through the Florida statutes, Florida Administrative Code, DBPR, and the Florida Real Estate Commission.